Why don't we begin? Hi, everyone. How's it going? My name's Russ Weninger. I'm an immigration lawyer at the Weninger Jong Law Firm. And this is the latest in our webinar series on COVID-19 and immigration. So today we're going to talk about uh, what happens when your application gets rejected. So your application is rejected. And now you have to decide, well, what to do next? What can I do to possibly rectify this situation? So that's the topic for today. Before we get into it, I want to give a shout out to some people and organizations who've helped promote this webinar, helped spread the word. So uh, CCIS, the Calgary Catholic Immigration Society, it was Jessica Wynn, actually, from CCIS. I was talking to, and that gave me the idea to do this webinar series, and then CCIS promoted the initial webinar, and we got quite a few viewers that day, and I'm hoping this webinar series is helpful to people, and I think it is. And but it all got started with that um, idea from CCIS and their initial promotion. So thank you so much to CCIS. Another person I'd like to thank is Sunny Liu. Sunny Liu's my articling student, and she's been doing a tremendous job helping me with this webinar series. She oftentimes is scrolling through the questions and comments in the chat room, and helping me to answer those questions, and letting me know when the audio isn't quite right. Things like that. So thank you so much, Sunny, for helping and providing all that back end support. And Sunny is within probably about 6 months of becoming a full-fledged lawyer. And when she's called to the bar, I'm sure she's going to be an excellent lawyer. So far, her training has been almost entirely in immigration law, although she's done a little bit of family law as well. She's helped me with some wills, helped me a little bit on some litigation files. So I think whatever Sunny ends up doing with her career, I think she's going to be a tremendous lawyer. So Sunny, thank you so much. I'd also like to thank my common law partner, Hiroko Nakao. At this point, everyone in my family is working from home. I'm working from home. My partner, Hiroko, she's working from home as well. And because I'm doing this webinar in the living room, and our office in the house is just down the hall from the living room, she's actually doing her work upstairs in the bedroom right now because she doesn't want to disturb me while I'm doing the webinar. So thank you so much, Hiroko, for accommodating me. And likewise, my daughter Natalie, she's doing her schoolwork, but she's upstairs in her bedroom right now so that I can do this webinar. So thank you so much to my family, my partner Hiroko, my daughter Natalie. I wouldn't be able to do this without your support. I should tell you a little bit about myself. As I mentioned earlier, my name is Russ Weninger. I'm an immigration lawyer with the Weninger Jong Law Firm. I am trying to slowly, over time, learn Japanese. It's a difficult language to learn, but I'm doing my best. When time permits, I try to work on that. As I mentioned last week, I'm a big fan of Korean dramas. The one I'm watching at the moment, I think it's called When the Magnolias Bloom. It's a good drama as well. I quite enjoy it. What else about me? I grew up in Pincher Creek. I don't know if anyone knows where Pincher Creek is, but it's this beautiful little town, right, almost in the corner of southern Alberta. So it's about 45 minutes to an hour from the Canada-U.S. border, and it's also about 45 minutes to an hour from the Alberta-BC border. So it's a neat little place, right on the kind of on the foothills. So it's very close to the mountains, but it's still on the prairies, basically. And so it's this amazing little town, about 3,500 to 5,000 people, I think. At least that's the way it was when I was growing up there. Now they've got a Walmart in Pincher Creek. When I was growing up, they didn't have a Walmart, so I was really excited when a 7-Eleven moved into town. What's famous about Pincher Creek? Well, actually, the former Supreme Court Chief Justice of the Supreme Court of Canada, Beverly McLaughlin, came from Pincher Creek. So there's Beverly McLaughlin, and then there's me, and I'm definitely not in that same league in terms of kind of, contribution to the legal profession or anything like that. But yeah, so that's a famous person from Pincher Creek, Beverly McLaughlin. I heard somewhere, I think maybe Diana Krall for a while was living in Pincher Creek. She's a jazz pianist, singer. Pincher Creek is extremely windy. It's one of the windiest places you could possibly imagine, and they've got a lot of wind farms there. And that's a growing industry in Pincher Creek is the wind industry. Wind power industry, but it's extremely windy. That's something I don't miss about Pincher Creek. Now I live in Calgary, which is a couple hours away from Pincher Creek. It's much less windy. It's much more mild in Calgary than it is in Pincher Creek. But definitely, if you get a chance to, Pincher is very close to Waterton, Waterton National Park. The Waterton Glacier International Peace Park is a national park, a couple of national parks actually. So there's Waterton on the Canadian side and Glacier on the U.S. side, and Waterton's actually kind of small in terms of national parks, but Glacier's quite a big national park. And so, yeah, these two parks combined are quite incredible. And Waterton's a very short drive from Pincher Creek. So if you ever get a chance to go down to Waterton, and I highly recommend going down to Waterton, stop in Pincher Creek and grab some lunch and do a little bit of shopping there. It's a beautiful little town. So enough about me, enough about where I came from. I'll talk a little bit about housekeeping briefly, and then I'll get right into the meat of the webinar today. It doesn't look like there are a lot of people online with me at the moment. Hopefully more people will tune in later. Maybe they'll watch it when it's just archived on YouTube. But in case you are watching the live stream, feel free to pipe in with any questions in the chat box. I'll be happy to answer as many questions as I can get to today. And it looks like it's a small group, so ask away if you've got any burning questions. Try not to make it too personal. So don't go into any really specific details about you or your family or your circumstances or whatever, because this is YouTube. This is out there for the world. So you don't necessarily want to be revealing all sorts of personal details. But if you have any, general I say that just after mentioning I grew up in Pitcher Creek and what kind of TV show I like and where my family's working at the moment. So, but anyways, for you, the viewers out there, you don't necessarily want to be revealing too much personal information in your chat, um, but you can hopefully phrase your questions in a more general way, or ask questions without revealing too much information about yourself, to protect your privacy. So if you have any questions, yeah, absolutely put them in the chat box, and I'll be happy to answer any questions that you put forward to the best of my ability. One thing I don't want to deal with, though, is, so back to the housekeeping, one thing I don't really want to deal with is other areas of law. So if you have questions, if you're asking a question about whether you can sue your employer or who fired you, or whether you can sue your landlord, or whether you can fight a DUI or something like that, I'm not going to get into other areas of law, just immigration law today. But if you have an immigration related question, feel free to ask away. And ask at any time. I'll take questions at the end, but I'll also take questions throughout the talk today. I'm not going to be discussing my firm's services or fees. This isn't about promoting Weninger Jong. It's about providing helpful content to my viewers out there who might be in dire circumstances at the moment, with being hit with the double whammy of having a layoff, possibly not being able to leave the country, so being trapped here, not being able to work, possibly, and then having immigration uncertainty hanging over your head. So it's kind of like a triple whammy for a lot of people. So that's why I'm doing this, to help you as much as possible, and yeah, so that's the focus. As I mentioned earlier, I'm going to be putting this on YouTube, so don't worry if you have to leave early. Don't worry if you have to kind of, watch it for a few minutes and then go and deal with your kids or with your spouse or something like that, or and then come back. It's you can come and go, or if you have to leave, you can watch it later on YouTube. So today, as I mentioned earlier, what I'm going to be talking about is what to do when your application gets rejected, what some possible options are for an application rejection. And this comes up all the time. And sometimes people think, well, if I hire an immigration lawyer or consultant or someone like that, then I'm not going to get a rejection on my application. That's not necessarily true either. I hate to say it. Well, actually, I don't hate to say it, because it's the simple fact of the matter. Even applications I do routinely get rejected. And I think that's the same with most immigration lawyers out there. I'm not going to say most of my applications get rejected or anything like that, but there's a significant percentage of my applications that do get rejected, and that's simply due to the fact that different people have different circumstances, and some applications are stronger than others, and you can only work with the circumstances that you're given. And sometimes people's circumstances aren't great, so sometimes applications succeed and sometimes they don't. And it's always a good idea to put your best foot forward and to try your best. And you always want to work towards the goal of having your application succeed, but The unfortunate fact of the matter is, some applications don't succeed, and then the issue is, so what do we do about that? Is there a way of rectifying that situation? And there are a number of reasons why applications might not succeed. So one reason might be kind of lack of preparedness when you're submitting the application. Maybe you haven't dotted all the i's and crossed all the t's, and you just didn't submit a very good application. um, in other cases, sometimes an application might not succeed, not necessarily because of anything you did wrong, or anything that was wrong with the application, but maybe the officer made a mistake. Maybe the person reviewing your application actually uh, uh, unfairly rejected your application. And when that happens, what do you do about that? Do you just let the government officer get away with an unreasonable or an unfair decision? Maybe that's the solution in some cases, uh, or maybe not. Maybe you have to push back in some cases. So we'll talk about the different strategies, and what you can do if you're faced with rejection. And sometimes it matters a fair bit whether or not the cause of the rejection was on your end, or if the rejection was more due to a misunderstanding or a mistake on the part of the immigration officer. So this kind of maybe goes without saying, and maybe it's very obvious what I'm saying, but sometimes for some people it doesn't even occur to them that this is a possibility. So the first thing that you can do when faced with rejection on an application, the first obvious possibility is to do nothing. So in some cases, either an application, you knew it was doomed to failure, or maybe the outcome of the application isn't really that important, or maybe it was something you tried and you were hoping it would work, but when it didn't work, you're accepting that. So in some cases, it makes sense to do absolutely nothing. So you apply for a work permit, or you apply for permanent residence, and it doesn't get approved, and you understand why it doesn't get approved, because you don't meet the criteria. Maybe that's it. Maybe you gave it a try, it didn't work, and now it's time to pack it in. So for some people, doing nothing might be a good strategy, and in some cases that's a tough pill to swallow. Sometimes people don't want to give up. We're taught as young children, even, you shouldn't quit. Don't be a quitter. Don't. I think it was on the Freakonomics podcast or somewhere. A number of years ago, I read an article, or I listened to a podcast where they were, basically, promoting the virtues of quitting, and saying how people should more frequently give up. Oftentimes we don't give up when we should, when it's rationally it makes sense to give up. Sometimes we don't do that because we feel we've invested too much into it to give up. Then that's sometimes known as a sunk cost fallacy. So you think, well, I've put so much time, I've put so much money, I've put so much effort into this. How can I possibly give up now? Well, in immigration, oftentimes people are in that boat. They've worked in Canada for a couple of years. They've spent money here. They've paid their taxes. They've you know, rented a place, maybe bought a car. They've put all this time, money, and energy into Canada, and they've made friends here and things like that. And then to have to give that up, like, why would you do that? Well, maybe you do that because your immigration prospects just aren't realistic, and maybe your life back in your home country isn't really that bad. So in a circumstance where you could go back to your home country and have a pretty decent life, and your immigration prospects in Canada really aren't that great, um, then maybe the solution is just to bite the bullet and go back home. And you came here once. You were able to meet the criteria for a work permit or a study permit or something like that. So you were able to get to Canada once. Maybe down the road, maybe in the future, you'll be able to come back to Canada. Maybe something will work out for you. You'll find an employer. You'll meet the criteria for a particular type of work permit or a particular immigration stream, and you'll be able to come back. Um, so that might be an option, is just to, if you're faced with insurmountable obstacles, at least for the moment, throw in the towel and just quit and go back home, and maybe down the road, opportunities will open up for you and you'll be able to come back, or maybe not, but maybe Canada just doesn't have the opportunities for you that you think it does. Sometimes doing nothing or giving up or quitting, sometimes that's the best strategy. So I'm not saying it's always the best strategy or it should be your strategy, but sometimes that is a strategy that's worth considering. So I thought I'd mention that. Now, another thing you can do when you're faced with a rejection is request a reconsideration. And in some cases that's worth trying, and in other cases maybe it isn't worth trying. If you think maybe the officer just made a simple mistake, or maybe you have some more information that you have readily available, you have immediately available this additional information that you think might change the officer's mind. In a situation like that, a reconsideration request might not be a bad idea. And to do a reconsideration, all you have to do is essentially write back to the officer. So when you get the rejection letter, send a web form request to the officer to reconsider your application, and explain why you want the officer to reconsider, and what evidence you have to back up the reconsideration request. Now, I should mention that probably at least 95 times out of 100, that reconsideration request is going to fall on deaf ears. So immigration officers, they're not required to reconsider a rejection. Once they've made a decision, that decision is considered to be a final decision. So they have discretion to reconsider their decision, but they don't have to. And so in the vast majority of cases, they're either not going to respond, or they're going to say, no, I'm not reconsidering, and that's that. And so in some cases, if you think maybe it was a simple mistake on the part of the officer, and you can point that mistake out to them quite easily, or if you have additional information that is very relevant that you think would change the officer's mind, you can ask to present that to the officer, and maybe they'll reconsider. But there isn't a requirement. Even in the case of a mistake on the part of the officer, some officers will say no. They'll say, sorry, I stand by my initial decision. A lot of officers are kind of stubborn that way, and so then you either have to live with the decision and move on, or you have to do something else. And what are those other things that you might be able to do? Um, well, you might be able to, in some cases, do some sort of an appeal, or you might be able to do a judicial review application. And those are two quite different things. Oftentimes people will come to my office or in this case contact me via Skype, because I'm not seeing clients at the office these days. But they'll come to me and they'll go, Russ, how can I appeal this? How, this officer, they didn't give me the time of day. They gave my application a very cursory review and rejected it out of hand. What can I do? How can I appeal this? Now, under Canadian immigration law, there are only certain types of applications that can actually be appealed. So there's a big distinction between appeals and judicial reviews. An appeal is an application where, or sorry, an appeal is a process where the decision maker, the person who's deciding the appeal, they can actually overturn the decision. So they can not only decide that the decision is wrong or unreasonable, but they can issue their own decision. So they can replace their decision for the original decision that the officer made. So that's an appeal where you can actually get a different decision at the end of the day. Now, contrast that with a judicial review. A judicial review is an application where, it's a process where, at the end of the day, the most you'll get out of it is the application being sent back to be redecided upon by another officer. So with a judicial review, you're not getting a new decision. The decision maker, well, you're getting a new decision, but it's a new decision that may be the same decision, and it's by an officer at the same level. So the judge who's hearing the judicial review application, the federal court justice, they're not issuing their own decision on whether your application will succeed or fail. They're simply sending the application back to the government office that processed the application to start processing that application again. And maybe that government office will come to the exact same decision using different reasons, maybe, but they might come to the exact same decision as that they originally came to. So that's a judicial review. A judicial review, even if you're successful in a judicial review, that doesn't mean you're ultimately successful. It just means that you're still playing the game. Your application is still being processed, but a win at a judicial review is not necessarily that doesn't necessarily mean you're going to get your visa or your permit or you're going to get permanent residence or anything like that. It just means that that you might still get those things, if that makes sense. Now, another thing about a judicial review application is it can't, uh, in most cases, it can't consider new information. And this is very important because in most cases, when people get a rejection, or I shouldn't say in most cases, I don't know if it's most of the time, but in many cases, when people get a rejection, they have something else that they want to submit. They have some extra information that they think might have changed things. Now, the problem with the judicial review application is that you can't present that new information because the federal court justice will say, I'm sorry, but that wasn't before the officer initially." And the reason for that is the test of a judicial review is whether or not the 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 officer who reviewed the application, whether they were acting unreasonably. So whether, based on the information they had in front of them, whether their decision was reasonable. That's the issue at stake in a judicial review application, or whether the officer made a legal error. So they interpreted the law incorrectly. Those are the issues that are before uh, a federal court justice when they're considering a judicial review application. And so new information typically can't be presented. There are some limited exceptions to that, but in the vast majority of cases, new information can't be presented in a judicial review application. So that very much limits the type of of information you can present in your defense in a judicial review application. Um, so one implication of that is if you're thinking about doing a judicial review application, your initial application that you submitted to the immigration officer, that should have been a very strong application. So it should have been a complete application. It should have had plenty of information, that plenty of evidence that would have allowed the initial officer to come to a positive decision. And uh, and if the application wasn't crafted in that way, so if the application has a bunch of holes and if it's missing information, if the evidence in the application tends to you know point in the direction of the officer making the decision that they actually made, then a judicial review application isn't right for you. It's only really right for someone in circumstances where the officer screwed up in some way, or the officer, really didn't take into account. Spilled a little bit of coffee on my hand. They didn't really take into account everything they should have taken into account. So that's when a judicial review application is appropriate. But if they rejected your application because your application was weak, or because you didn't provide everything you should have provided, or for that sort of reason, then a judicial review shouldn't be pursued. Um, Now, contrast that with an appeal. An appeal is a little bit different. Sometimes uh, an application that's appealed, or when a rejection happens on an application and that rejection is appealed, um, in many cases, new evidence can actually be submitted for the appeal. That's a little different from other types of appeals. So if you're, for example, suing someone in civil court, and you get a negative decision and you want to go and appeal that negative decision, you're limited in that context to evidence that was before the first court. But in an immigration context where you're dealing with immigration tribunals that that tend to be hearing these appeals. So there are a few different immigration tribunals or a couple of, I should say, that will hear appeals. So there's the refugee the Refugee Appeal Division, the RAD, that hears appeals on rejected refugee claims. And then there's the Immigration Appeal Division that hears appeals on other things that can be appealed. For example, a spousal sponsorship rejection, or a determination of inadmissibility, or a determination that a permanent resident hasn't satisfied the residency requirement for maintaining permanent resident status. So those sorts of things can be appealed, and they're appealed to the Immigration Appeal Division. Uh, so, uh, so those immigration tribunals that are hearing appeals, they can actually consider new evidence. So that's very important. To be aware of that distinction between an appeal and a judicial review, and um, and and in an appeal, like I mentioned earlier, they can actually issue a new decision. So they can decide that not only did uh, the initial officer, decide incorrectly in making their decision, but they can actually issue a new decision. So they can say this person should get their permanent residence, or this person, is not inadmissible, or this person is eligible to sponsor this other person. Um, so so yeah, the appeal is quite a bit different from a judicial review. It's more permissive in a lot of respects. Now, the problem with appeals, though, is that they're limited in scope. Or I mean, there are a lot of immigration decisions that aren't subject to review by appeal. Um, for example, if you're just applying for a normal work permit, or if you're just applying for a normal visa to come to Canada, you can't appeal rejections on those applications. You At most, you can judicially review those applications. You can appeal a failed refugee claim, at least in most cases. You can appeal, as I mentioned earlier, a determination that you haven't met the residency requirement for maintaining permanent residence. You can appeal um, a rejected spousal sponsorship application, as long as that spousal sponsorship application was an out of Canada spousal sponsorship application. So, or I should say, a family class spousal sponsorship application. So if you use the in Canada sponsorship procedure for spousal sponsorship, you if you get a rejection, you can't do an appeal on that. You actually have to do a judicial review on that. So there is a bit of a distinction uh, between, or I shouldn't say there's a distinction. There's a big difference in uh, certain types of immigration applications in terms of whether you can appeal or whether you have to judicially review. And as a general review, or as a general rule, if there is an appeal option, you have to pursue that appeal option before you can judicially review. So, for example, if you get a failed refugee claim, or if you get a rejection on a refugee claim, and you want to then um, overcome that rejection, you can't just, in that case, go to a judicial review, because uh, you you do have the option to go to the Refugee Appeal Division, and you have to, first of all, exercise that option and appeal to the Refugee Appeal Division. And then only if you get a rejection at the Refugee Appeal Division can you then do a judicial review. So if you have an appeal option, you have to exercise it before you can then do a judicial review. Um, so, uh, so in some cases, it makes sense to appeal or judicially review an application. For appeals, I've talked a little bit about when it makes sense to judicially review an application. So essentially, if if you can demonstrate quite clearly that the visa officer made a mistake based on the evidence that was available to them, then or that they were unreasonable. So it's not necessarily the case that the officer's decision was incorrect, but that they, um, based on the evidence available to them, there and the reasons that they stated for coming to the decision, that based on that, their decision was unreasonable. So if you can demonstrate something like that, then you have good grounds for a judicial review. For an appeal, um, in some cases, maybe the initial officer's decision was even technically correct, but uh, at the appeal level, you might have additional grounds that you can argue. So, for example, sometimes at the appeal level, they can consider humanitarian circumstances, whereas at the lower level, so for example, sometimes when you're appealing a decision that was made at the immigration division level, um, and you're appealing to the immigration appeal division, you can make humanitarian arguments in some cases, whereas at the immigration division, you might not have been able to make those same arguments. Uh, so so in some cases, an appeal is a good idea, even if your initial application had a lot of flaws in it, or even if um, there was information that could have been provided that wasn't provided, or that um, so in a situation where you have new information and it could change the outcome, um, uh, even if the initial application was a little bit defective, it may still be worthwhile uh, doing an appeal. Um, i- a- an exception to that is basically an appeal to the RAD. So if you made a refugee claim and that refugee claim got rejected, uh, there are limited circumstances in which the RAD, the Refugee Appeal Division, will consider new evidence. But in most cases, they stick with the evidence that was presented at the initial refugee hearing before the Refugee Protection Division. But yeah, in some cases at the appeal level, a tribunal can consider new evidence, and they're not just stuck determining whether or not the initial visa officer or immigration officer's decision was unreasonable or legally correct. Um, so so yeah, whether or not to do an appeal, oftentimes is based on whether you have the evidence that's necessary to convince the person who will be deciding the appeal, the tribunal member, whether you have enough evidence to convince them that the decision you want is a good decision, basically. Um, Now, in some cases, you might have appeal options or judicial review options, or maybe you don't even have those options anymore. Um, uh, if a person, they submit an application and they get a rejection, and a certain period of time has passed, they might not any longer have the ability to do an appeal or a judicial review. So when you get a rejection on an application, typically, if it's a decision made in Canada, you have 15 days to file a judicial review application, or what's called a leave application for judicial review. Um, and and if it's a decision made outside of Canada at a visa office, let's say outside of Canada, then you have 60 days to uh, submit a leave application for judicial review. And if you're outside of that time frame, you might not even be able to submit a leave application. In some cases, people can ask for an extension of time, uh, but that extension may or may not be granted. So your right to file a leave application for judicial review uh, may end if a certain period of time has passed, and that also applies to appeals. So typically, with an appeal, you'll have like 30 days or 60 days or something like that in which to bring that appeal. And if you don't, then you won't have appeal opportunities later on. In some cases, you can apply for an extension of time. And now I should mention that with appeals, when I'm talking about timelines to file the appeal, it's just to file the appeal. So that doesn't mean you have to necessarily provide all the information right away for what you're going to argue, but to file the initial paperwork to get your foot in the door for that appeal. Um, so yeah, you're given a certain limited window of time in which to appeal, and if you miss that window, you might be out of luck. Now, fortunately, right now with COVID-19, there are situations where people might ordinarily be outside of their window for doing an appeal, or they might ordinarily be outside of the window for doing a judicial review. But because the federal court has basically been shut down, and a lot of the immigration tribunals have basically been shut down, you may still have those appeal opportunities or those judicial review opportunities, even though ordinarily you'd be outside of the normal timeline. So if you are within the normal timeline, you might have those opportunities. If you're not within that timeline, or even if you are within that timeline, but you don't think you're going to get a good outcome by doing an appeal or by doing a judicial review application, the option the option worth pursuing might not be to do an appeal or to do a judicial review. It might be simply to resubmit your application. That's something that people oftentimes aren't aware of. Sometimes people think, once I get a decision on an application, I'm stuck with that decision forever. Unless I appeal it, I can't. So let's say I submit an application for spousal sponsorship. If it gets rejected, I'm never going to be able to do a new application again. That's usually not the case. So in the vast majority of cases, when an application gets rejected, an option you have is to resubmit the application. You might get the exact same outcome. So if the officer rejected your application initially for certain reasons, and with the new application, those reasons still apply, then you might get a rejection again. But it might be the case, for example, let's say you initially submitted a weak application, but you get the rejection and you realize, okay, I could have done X, Y, and Z differently. So I could have, I was applying for a work permit, but I didn't provide enough evidence about my previous work experience, and now I've got employer reference letters. In a situation like that, maybe the second time around, the application will actually be approved, even though the first time it got rejected. So resubmitting an application is is oftentimes the way to go. And in fact, I think in the vast majority of applications that are rejected, um, if the person, still really wants to come to Canada, or still really wants to work or study in Canada or visit Canada, or something along those lines, then the remedy for them that they actually pursue is the remedy of resubmission. So uh, yeah, in the vast majority of cases, they don't pursue appeals. Rejected applicants don't pursue judicial reviews. They actually go ahead with another application for the same thing in many cases. And the second time around it might work, or the third time around it might work. Each officer can make their own decision, and when you resubmit an application, chances are it will be going to a new officer the second time around. So if you think the first time uh, around, maybe your application wasn't super strong, and maybe now you were able to get information that would have addressed the concerns of the officer for the first application, and then you're in a good position for a resubmission. I think if you've got that information that addresses the earlier officer's concerns, then I think you're in a good spot to make use of that strategy of resubmission. And oftentimes, so common reasons why applications are rejected. So, for example, work permit applications or visitor visa applications or things like that. Um, a very common reason is insufficient documentation. Uh, so, uh, so, for example, in a study permit application, oftentimes people won't provide enough information about the purpose of study, of their studying, or the reasons for studying. Um, they won't provide enough information about their finances, how they're going to support themselves while they're studying, um, and and once they're aware of that, once they get that initial rejection, then they can go back and collect that information, provide the reasons for studying, provide the information about their financial situation. So, um, so when resubmitting, that's the opportunity to go back and look for that information that maybe you didn't provide the first time, that could have made a difference. Um, and one way to do that, one way to make sure that you're providing uh, all the information that you can, that may have changed things the first time you submitted your application, had that information been available. um, the way you can uh, effectively do that in many cases is by doing what's called an access to information, or an ATIP request. So if you get a rejection, this isn't always possible, because sometimes you don't have the luxury of time and you have to do something right away. You have to submit a new application right away, or you have to file a judicial review right away, or something like that. So sometimes you don't have the luxury of time. But if you do have the luxury of time, then I'd recommend, if you're faced with a rejection, do an access to information request. So ask for the uh, I think it usually costs about $5 or $10 or something like that to do one of those requests. And you can request the immigration officer's notes, and you can find out what the real reasons were for the rejection, because sometimes the letter they send to you is just very vague, and they say, well, you didn't satisfy us that you had the financial, you know security necessary to pursue a program of studies in Canada or something like that. Um, so they'll send you this vague rejection letter, but when you actually read the notes, the officer goes into maybe a bit more detail about why they didn't like your application. And when you see those notes, maybe a light bulb goes off in your head, and you go, "Oh, yeah, okay. So if I'd only provided this document, then maybe things would have been different." And so the use of those ATIPs, those access to information requests, can be very valuable, especially for things like study permit rejections, work permit rejections, things like that, visitor visa rejections. But you have to have the luxury of time. In most cases, under good circumstances, it'll take at least a month to 2 months to get an ATIP approved, or I mean, to get it processed, to get um, your the records you've requested, to get them sent to you. Um, so that's 1 to 2 months under normal circumstances, but under COVID-19 circumstances, you might be waiting a full year, um, or maybe longer than that. So, because so many government officers are working from home at the moment. Um, so with an access to information request, if your situation is very urgent, you might not have time for that. So you might just resubmit. Take a guess at why the immigration officer rejected your application. In some cases, it's obvious. In some cases, maybe if they say they weren't satisfied that you had the financial resources to cover studies in Canada, for example. You probably know why that is. You're probably aware of what you put in the application, and what kind of financial records and things like that you provided, and maybe they're right. Maybe you don't have the finances for your program of study. So uh, and then that would go back to the earlier recommendation of maybe doing nothing. Maybe you just have to bite the bullet and accept that the officer made the right decision based on your circumstances. Um, but if you do have the finances, and you just didn't provide your bank statements, or your proof of investments, or proof of property ownership, or whatever, then now you can go ahead and do that. Um, uh, I didn't go over updates, but I think now might be a good time to chat a little bit about this week's updates, because there were some major updates that may affect some people, and I think are quite important. So yesterday, the government announced that they might be expediting work permit approvals for certain temporary foreign workers. And they also announced that people could actually, in some limited circumstances, start working even before they get a work permit. Now, before you start jumping up in the air and going, whoop de doo, everything's all wonderful now. I my thinking is that this government announcement isn't as great as they're making it out to be. Um, what the announcement said is that to to change work, if you're a temporary foreign worker and you want to change work, uh, for one thing, you have to currently be in valid status as a worker in most cases. So if you're not currently under valid worker status, then this doesn't apply to you. At least on the face of it, based on the government announcement, it doesn't apply to you. So you have to be currently working, and in most cases, you'll have to be currently working under a labor market impact assessment based work permit, an LMIA based work permit. Um, Now, so what the government announcement is that you can switch to a new employer, and you can start working right away. But you have to do a few things. So you actually have to submit a work permit application, and then you have to contact the government and on the web form and say, by the way, I've submitted this work permit application, and so I want to start work as soon as possible. And so you have to go through a few hoops, and uh, but here's the catch. In most cases, the employer is going to have to either have, or they're going to have to qualify, and I suspect that in most cases they'll have to have it already, a valid labor market impact assessment. So they'll have to have already been approved for an LMIA, and that's the thing that sometimes takes a while to get. Even if the employer qualifies for an LMIA, it might take a few months to get that in some cases. And the employer, just to get to the stage where they can apply for an LMIA, they're going to have to do job interviews, and they're going to have to advertise the position, and they're going to have to do a number of different things. And at the end of the day, they might not qualify for the LMIA anyway. So it's only really for employers who qualify for an LMIA, or there are some circumstances, for example, under the International Mobility Program, say young professional or something like that, where an employer might be able to, rather than do an LMIA, they might be able to issue a job offer under the employer portal. And so in those sorts of cases, maybe the person can qualify for a work permit in Canada without even having to go to the border to get their work permit, or to leave Canada to get their work permit, as they ordinarily have to do under something like the Young Professional Program. So for workers or prospective workers with employers who have LMIAs already approved, this announcement is a positive announcement. For workers who might qualify under the Young Professional Program, or something like that, International Co-op Program or whatever, for some of those workers, this might be okay. This might be a positive thing. For a lot of people, though, who are out of status, or who are here on open work permits, or they don't have an employer lined up who's going to qualify for an LMIA, those people are left out by this announcement. So I think the number of people who are actually going to benefit from this government announcement is a small fraction of the people who need government support. And I think the problem too is that a lot of people are going to apply, and they're going to get quick approval to work temporarily, but then their work permit applications are ultimately going to be rejected because the employer didn't qualify for an LMIA, or for some reason like that. It's kind of like the problem with the CERB benefit, the Canada Emergency Response Benefit. A lot of people are getting the money from that benefit even though they don't qualify, and the government isn't really vetting that. At the initial application stage, they're just giving people money if they ask for it, and then maybe later on they come back and sue people for that, or deduct it from their tax refunds, or and maybe they're charging interest, maybe they're charging penalties, maybe they're prosecuting people for fraud a year down the road when the dust settles on COVID-19. So with CERB, it's been a bit of there's been this problem of people who probably shouldn't be getting the money. And likewise, I think that's going to be a problem with this work permit announcement is people, I don't think they'll get work permits, but they'll be permitted to initially start working for new employers. And then work permit applications will end up later on being rejected, and then they'll have to stop working. So I'm not left with a warm fuzzy feeling about this government announcement. I think it'll benefit some people, but I don't think it's going to benefit as many people as it could. It ideally would benefit. Um, so, uh, what would I do if I were Prime Minister of Canada or Immigration Minister? I would give provisional worker status to every foreign national living in Canada. That would be what I'd do. If we're talking about bold, outside of the box thinking, which the government has demonstrated it's capable of doing, because in all these other areas, it's provided billions of dollars. It's turned on a dime by changing all these government programs to help keep businesses afloat, to protect people who've been laid off in many cases. So the government has shown that it can think outside of the box and adapt to these really unusual circumstances. If I were immigration minister, that's what I would do, and I would say provisionally for the time being. Um, and without prejudice to status down the road, we're going to uh, give everyone in Canada provisional worker status. That's what I would do. Now, if you're just tuning in, the government isn't doing that, so don't think that's the case, that everyone has provisional worker status. But that would be my solution, and I think there would be very few drawbacks to that, because let's say the person's even been living in Canada out of status for 10 years or something like that. At this point, they can't leave. They can't go back to their home country in most cases, because flights aren't going back to their home country. And they might have mouths to feed in Canada. They might have kids. They might have spouses. And they have rent to pay, so they have landlords and people like that who are depending on them for you know uh, for income support. Um, so I think the benefits would far outweigh the cons of giving everyone provisional worker status. There might have to be some exceptions to that, but I think on the whole, giving everyone provisional worker status and thereby allowing them to apply for things like provincial health coverage, the pros would far outweigh the cons, and you could revoke that provisional worker status. Well, then you have to figure things out at that time. But for the time being, to just say anyone who's in Canada, even if they're not a Canadian citizen or a permanent resident, they can work. That would be my solution. So unfortunately, I won't ever be immigration minister or prime minister or anything like that. But that would be the policy I would strongly advocate for. If any government officer is ever watching this video, please work. Don't make it a crime to be working, to be supporting your family during this COVID-19 crisis. These are very exceptional circumstances, and to be nickeling and diming people to over making very incremental changes to immigration policy when in all other areas the government has shown that they can think outside the box and make bold, decisive steps, being very risk averse and very nitpicky with immigration policy. I think they're embarrassing themselves. I think they're not doing enough to help the most vulnerable in Canada. And the most vulnerable are people with precarious status, or people who are limited to a single employer, and also people in long-term care facilities and places like that. We saw one of the biggest outbreaks in Canada. I think it was the biggest outbreak was at the Cargill meat processing plant. And a lot of those people, they're temporary foreign workers. They've got to go to work. They don't have a choice of employers. They can't opt to go and work at a nearby McDonald's or a nearby Tim Hortons or something like that. A lot of those workers have no choice but to work for that single and it breaks in a facility because people don't have a choice. They can't stay home, and they face pressure to work even when they're sick. Um, so you want to prevent that. You want to protect the most vulnerable in society. You want to um, uh, you know do as much as you can to protect people who are in dire circumstances. Uh, be bold and decisive, and allow as many people as possible to work. Um, that's my recommendation. Take it for what it's worth. Um, Resources. In about an hour's time or less than an hour, there's going to be a webinar similar to this webinar, maybe better, hopefully better, um, through Center for Newcomers. And it's a friend of mine, a colleague from another law firm, Shorey Law. His name's Jatin Shorey. He's going to be doing this webinar, so I'd recommend checking that out. I think it's through maybe Center for Newcomers YouTube channel, possibly, maybe Shorey Law YouTube channel, and I can't remember offhand, but that might be worth checking out. So that's at noon. So that's something I recommend checking out. So YouTube live stream sessions, and he does them frequently. He does them several times a week, usually. So I'd strongly recommend checking out Mark Holtby's YouTube channel, watching his YouTube live streams. He's extremely informative. He's very well connected. People in government, with immigration officers. So Mark is a wealth of knowledge, and he provides really good content. So I'd strongly recommend checking out Mark Holthy's Holthe. I'd recommend checking out his YouTube channel. So yeah, Jatin Shorey's webinar through Center for Newcomers, Mark Holthy's stuff on his YouTube channel. Those are some resources I'd recommend checking out this week. And yeah, if you have any questions or comments, I didn't really have anyone sending in questions today. I was looking at the chat box all throughout the webinar today, and no one sent in a question. Only a few people are watching today, it looks like. So that's fine. Maybe people will get more benefit from this on the archived version of this video on YouTube. But if you do have any questions, reach out to me either through the comment section or send me an email. If it's just a quick one-off thing, I can probably just respond back in an email. But if it's something that requires a more in-depth response, then I can book a consultation with you. But obviously, I'll have to charge for that. Once again, I'd like to thank my student, Sunny Liu, for helping me. And it's not just with this webinar that she helps me. Sunny has been doing work on files for virtually all of my immigration clients. And without her assistance, I wouldn't be able to do things like this webinar. I simply wouldn't have the time for that. So thank you so much, Sunny, for helping out. And yeah, thank you as viewers for watching and making it worthwhile for me to provide this content to you. And If you have any questions, as I mentioned, feel free to mention them in the comment section or reach out to me. If you have any suggestions for content on this channel, feel free to let me know that. My plan is in the very near future to start putting content up on the channel about humanitarian and compassionate grounds applications. So I'm planning on doing a simple course on humanitarian and compassionate grounds application and putting that up on the Weninger Jong Office YouTube channel. So that's what I'm planning on doing in terms of content on the channel. But if you have other suggestions, there are other things that might benefit you, let me know, and I'm happy to consider that. And I, there's a very good chance I'll accept your suggestion and provide that content on the channel as well. Um, during these times, quite frankly, the focus has shifted. Uh, Down the road when things get more stable, uh, then I'll look towards monetizing my immigration practice. But at the moment, I'm making enough to make a living. At this point, my focus is helping as many people as I possibly can, and I think the way to do that is through free content online. So if you can't afford a lawyer, I think you should always try to get a lawyer if you can afford it. But if you can't afford an immigration lawyer and you need help, um, let me know what sort of application you're interested in doing, and I'll try to provide as much free content as I possibly can about that type of application or those types of applications, so that you and others can benefit from that. Well, thank you very much for watching, and I hope to see you next week. I'll be doing it same time, same place, next Wednesday at 10. Thank you. See you next week. Bye.